Thank you, Mr. Chairman. Congratulations, gentlemen. Just to clear up any confusion, Judge, do you believe that racially separate but equal, supposedly equal schools is immoral as a policy?
I would, yes, I do. In fact,
How about you, Counselor?
Yes, I do, Senator.
Okay, thanks. I'm not trying to trick you. I just want to understand how you think. I think we can agree that when Congress or a legislature passes a law, a statute, they're trying to solve a problem. You're familiar with the plain meaning doctrine. You don't go beyond the words of the statute in interpreting the statute if it's clear and unambiguous. Correct? You both know what I'm talking about.
yes, Senator.
Well, even if you think the words are clear and unambiguous, why would it be inappropriate for a judge to look further into the problem that the legislature or the Congress, as the case may be, was trying to solve? What's wrong with belt and suspenders?
Well, I think the simplest answer that I can give to that, Senator, is judges are not elected officials. They have positions for life. That's up to the legislator to make the law.
I know, but they have made the law, okay? And you look at the statute, and the words are clear. I'm just asking, what's wrong with looking behind the statute, looking at the legislative history, just to be sure that you got the plain meaning right? Either of you.
Senator, I think the answer to that is we know that the Supreme Court has said what you've just articulated, which is that if text is clear, then that's the end of the inquiry. I think the reasoning behind that, which is what you're getting at, is that the enacted text, if we understand what that means, then that's the surest guide to what the statute's purpose and intent is. And you should look no further, because if you started looking at legislative history, that's not what was enacted, and it might lead you down the wrong road.
Okay. So you would both say stick with the plain language, so long as it's unambiguous.
Senator, I believe that that's what Supreme Court precedent shows, and that's
Okay.
what I would do.
That's fair. There's no right or wrong answer. You agree with that, Judge?
I would agree, Senator.
Okay. All right. Then why do we pay attention to the Federalist Papers? I mean, there were 55 delegates who drafted the Constitution. There were three gentlemen that happened to write that wrote the Federalist Papers. Why do we care what they think? There's just one point of view. Should we care what they think? Either of you.
Senator, I was going to say that I think there are some cases, and you were talking about cases where we know the text is clear. There may be cases, and this is really obviously more for the U.S. Supreme Court, where it may be text the Supreme Court hasn't interpreted before, or it hasn't been interpreted for a long time. And I think that in some cases, the Supreme Court has looked at, if you will, a historical reconstruction of what was going on. I think in some of those cases, they would look to the Federalist Papers and other similar sources, which are indications of what was going on at the time that it was ratified.
Judge, you got any thoughts on that?
I would agree. I think that the use of the Federalist Papers is a good idea when there's a controversy that we're having trouble figuring out what the original public meaning is. I think it's a very useful tool, a very informative tool. It was made contemporaneously at the time, and that's the value that I can see in utilizing the Federalist Papers.
Let me ask you one last question, gentlemen. I'm not asking you to give me an opinion. I'm asking you to tell me what the law is here. Let's suppose that the federal government or the President of the United States, not necessarily this president, but any president, said to our universities, I'm going to withhold all your federal money if you don't investigate, prosecute, and punish, fraternities or sororities that hold parties where members drink in excess. You with me? Do those students enjoy the protection of the Bill of Rights if the universities proceed against them?
Yes, Senator, they do.
I agree with Justice Pittman. They would enjoy the protections of the Bill of Rights.
Okay, thanks, gentlemen.